Hello and welcome to the YouTube channel of Vidhi Culture. We are here with the legal updates today of the 21st July 2022. And in this session, we will discuss about the important judgment pronounced by the Delhi High Court with respect to the 13-year-old sexual assault victim who has been allowed to terminate a 25-week pregnancy. So this is an important judgment. So what happened in this case that father of this victim went to the court to get the permission that the pregnancy can be terminated because it is now 25 weeks. It is more than 24 weeks, which is the maximum limit up to which one can be the pregnancy can be terminated. So in this case, the Delhi High Court seen it as an extraordinary case and allowed the victim to terminate the pregnancy after the 25-week also. So let's read this out. So here the court was dealing with the position or the petition by the girl's father seeking the termination of pregnancy conceived out of the sexual assault. So this girl faced the sexual assault and out of this she got pregnant. The father is approaching the court. The family approached the court on the advice of hospitals. So the family first went to the hospital, and then the concerned hospital advised them that it is not within their ambit to get this pregnancy terminated. So you have to take the permission from the court first, then only we can do the further procedure. That's why they approached the Delhi High Court. Delhi High Court observed that a teenage girl misery and suffering would only compound if she is forced to bear the motherhood at such a tender age, while allowing a 13-year-old girl who became pregnant from a sexual assault to terminate her 25-week-old fetus. तो यहाँ पे हाई कोर्ट ने ऑब्जर्व किया दैट इट विल फर्दर एग्रीवेट द सिचुएशन फॉर द टीनेज गर्ल. अभी वो इतनी कम उम्र की है कि it is not possible for her to bear this burden of motherhood at this point of time. So that is why the court permitted that in the 25th week also she can terminate the fetus. Then the High Court also noted that the provisions of medical termination of pregnancy, that is MTP Act 1971, were to be strictly construed. They do not sanction termination of pregnancy beyond 24 weeks period. कहता है कि अगर हम MTP Act को देखें तो वहां पे डेफिनेटली ऐसा लिखा है कि beyond 24 weeks it is not allowed. But previous decisions have recognized that courts can invoke their extraordinary powers under the Constitution in exceptional circumstances and order termination of pregnancy. लेकिन यहाँ पे साथ ही हाई कोर्ट ने ये तो माना कि yes, in the MTP Act it is not allowed to terminate the child or terminate the fetus after 24 weeks. But in the previous many decisions, it has been recognized that in extraordinary situations, the court can use its power. Okay, in exceptional circumstances, it can use its power and order the termination of the pregnancy. Then the High Court further said that if any case can fall into the extraordinary category, अगर कोई भी जो केस है वो extraordinary category में fall करता है, like the present one, otherwise it will be invasion of her right to life under Article 21 of the Constitution. अगर यहाँ पे इस एक्सेप्शनल सिचुएशन में एक्स्ट्राऑर्डिनरी जो यहाँ पे पावर है कोर्ट की, अगर वो यूज नहीं करता, देन इट विल बी द invasion of Article 21 which talks about the right to life. तो यहाँ पे right to life का हनन होगा अगर यहाँ पे ये रिलीफ यहाँ पर विक्टिम को नहीं दिया जाता है. So in this landmark judgment by the Delhi High Court, she's been allowed to terminate the fetus in the 25th week. So this was about this judgment. Thank you so much. Thank you for joining. Bye bye. Take care.